Our Justice Thursday conversation today will border around the role of communications and multimedia appeals tribunal in enhancing access to justice. We talk about access to justice and we talk about enhancing it as one of the roads that the Chief Justice took. And to help us out with that conversation this morning is the Honourable Rosemary Kuria, who's the Chairperson of the Communications and Multimedia Appeals Tribunal. Has been here before, but happy to have you here as well this morning. Good morning.
Morning to you, and thank you for having me again.
How are you doing?
I'm doing very well.
Karibu sana.
Asante.
Let's welcome you to the Situation Room, as CT normally does, with a proverb. He'll tell you where it's from, and then you can tell us what your interpretation of that is.
Yes, our proverbs for the whole of this week come from the Republic of Zimbabwe, formerly known as Rhodesia. The proverb, don't throw out the old pot until you have the tinker make you a new one. Tinker is a person who
tinkers about,
who tinkers about and makes a pot or a sufuria or what are those Chinese bowl-like things that people use for frying things?
Wok.
Yes, wok. That's a tinker.
Yeah.
Yes. What do you think this proverb means?
Just say it again so that
I will say it again.
Yes.
Don't throw out the old pot until you have the tinker make you a new one.
City, you have talked about the problems on our continent,
yes.
And I would be thinking that would be saying that it is possible that to adopt systems from other places, untested systems, before we are ready, before we could move towards a new direction, or maybe probably there are things that we have that have been working, and instead of, we can even jump to adopt what other people are bringing to us before we have established that what we have isn't working. So I think it would be premature to believe that we must adopt something else from other people when our systems are probably working. They are not even broken.
Absolutely correct.
Yeah.
You've interpreted it. In fact, you've given it very good context. Thank
Indeed.
you.
Yeah.
Thank you so much for that.
Yeah. Thank you.
So it is Justice Thursday. We're looking at some of these things. Enhancing access to justice is around the conversations that we've had, for, a number of years now. And being able to look at this, really then how are we bringing, justice and the information of it to, people on the ground so you can actually access it. And today we're doing this in relation to the role of the Communication and Multimedia Appeals Tribunal. To start off, that this tribunal exists for a lot of people is news. So we would like to know a little bit about the tribunal and why it was set up in the first place before we go into, more details of it.
Thank you, Ndu. I think before we even get to talk about the Communications and Multimedia Appeals Tribunal, I'd like to let our people know that my appearance today is also part of a countdown to a launch of a secretariat in the Western region for the Office of the Registrar of Tribunals. And we are taking this opportunity as we move towards the launch, which will take place in May in Kisumu, that we continue to tell our people what tribunals are,
right,
so that we lay a context for the launch. Now, when we come to the Communications and Multimedia Appeals Tribunal, the communications, and we call it CAMAT, it is established under the Kenya Information and Communications Act, and it has two key jurisdictions. And when you talk about jurisdictions, we are talking about the court's mandate to hear decisions. That's what jurisdiction is talking about. And when you talk about jurisdiction, you also talk about the scope. So you talk about the topic and also the scope. And as far as the scope of our tribunal is concerned, it is set up to hear complaints against in relation to media. When persons believe that media enterprises have infringed on their rights, they can come to our tribunal. But I need to be quick to add that that jurisdiction does not include the ability to issue compensation, because I know for a fact that most people, when they are grieved, they desire to be compensated. So most of the times what we are allowed to do is probably demand, order that a party, for instance, a media enterprise retracts maybe an offensive publication, probably what else? And if a violation against a person is egregious enough, probably they can be fined up to 20 million. So that is one jurisdiction. The next jurisdiction is in relation to appeals. And I think when we were here, I still said, and I think I would repeat that I see that as the core jurisdiction of our tribunal. And it is we also hear appeals from decisions made by the regulator, and the regulator is the Communications Authority of Kenya. We also have jurisdiction to hear appeals from decisions made by the Media Council of Kenya. So, and those decisions relate to telecommunications. So there are decisions relating to the telecommunications companies, the telcos, the media enterprises, and postal and courier services. So that is the breadth, the scope within which those decisions will be made as far as appeals are concerned. And those decisions will be in relation to licensing, whether due process was followed. That is normally the major complaint. That, for instance, that a license was revoked without giving the party, maybe a media or a telco, an opportunity to be heard. So that is the general landscape of what we'll be dealing with as far as appeals are concerned.
Why was it important to have a tribunal around this sector, around communications and multimedia? And to say that, was there so much that was going on? There's so much in terms of, grievances, that it was important to have this sector then looked into.
I think I would not necessarily say that. I wouldn't say that there's necessarily a huge, tsunami of cases coming from that area. But I think what we have found is that I think there has been a desire to ensure that you have sector-specific courts, because sometimes some sectors are so specialized that you want to create a court that hears those cases specifically, so that they are able to develop very, very specific jurisprudence. And when you talk about jurisprudence, you are really referring to a philosophy of law concerning a particular sector. For instance, you get, and you have it in environment, you'll have it in aviation, you'll have in competition. So we are trying to create. Because what will normally happen is that when a court like our tribunal continuously hears cases from a specific area, they develop a robustness around it, so that at the end of the day, and since the people who are coming to our tribunal bring similar cases over and over again, then we are able to develop a very, very strong jurisprudence and a very, very well-informed one, because the people who are coming to us are from a very, very specific sector. And if you think about, for instance, the telecommunications sector, it's a highly dynamic sector. It's continuously new issues arising. I think it's important to have a tribunal that hears cases quickly, because they need to be heard quickly, because new issues are coming up. In fact, I don't know whether I mentioned here the last time that there's a case we had, and by the time we were hearing it, everything had become obsolete. New issues had emerged. So it is important, for instance, as far as the telecommunication, our tribunal is concerned, that we are able, that cases come to us and we hear them very quickly, so that we don't get caught up, because there are new and emerging areas coming up, especially in the telecommunications sector. And I believe even also in media, because there are even new players. For instance, you have the legacy media.
Yes.
But there are also other media coming out there, and there are also the questions: who regulates?
Absolutely.
The people who are having their podcasts, the ones. I mean, we have all sorts of experts and pundits cropping up every day, and who is regulating that kind of information? So I think it's important. Therefore, we have CAMAT, because if it is properly empowered, then it will be in a position to be able to address all of these emerging issues. Yes.
Why regulate? Why must we regulate? Why is it important to regulate?
I think it's regulate because every system is subject to abuse. For instance, when you're talking about an authority like communication authority and other public agencies, there is always the risk of the exercise of arbitrary power. Anybody...
and their 10 cousins.
When they talk about power corrupting, I don't think it speaks to the inherent corruptness of our people or corruption in our people. I think it's a worldwide that any system is subject to abuse. There is you talk about arbitrary decision making. For instance, you can find that, for instance, supposing a decision is made by the authority as far as KTN is concerned, but when it is another media enterprise, they come with a completely different decision. So we want to ensure there is a fair playing ground. So regulation serves to ensure to prevent excesses.
So that is why we have the law. So much as you have rights and you have freedoms,
Yes.
they are within the law.
Absolutely.
Yes.
Yes, absolutely.
So the freedoms exist,
Yes.
but they are not entirely absolute, so that you have the freedom to do exactly what you want. It doesn't quite work that way, does it?
It doesn't work that. And you remember what Martin Luther King Jr. says, that your freedom ends where my nose begins. So it's a question of ensuring that there are limits. There are limits to exercise of power and authority, because it's always prone to abuse. I think that's a given.
Yeah. So if I have a matter that I need to be handled by your tribunal, one would ask, what's the process?
The process now for our tribunal, and most of tribunals, we have an e-filing. We file. We don't do paper. So there's an e-filing process. So we do have. So there is a CTA, a case tracking system that has been established by the judiciary. So all you do is that you prepare your documents, you prepare your complaint or your appeal, and then you create an account within the Communications and Multimedia Appeals Tribunal platform, and then now you are able to upload the documents, and then immediately you upload them, and you'll have already, of course, input all your details and whatnot, and then the party you're suing. It is automatic. It's in real time, if I would say so. The filing fee, which is normally quite conservative, is assessed. Then you are able to pay the comfort of your M-Pesa, and then the case is received. If it comes, once it is received, the tribunal, that is myself, and we have 6 members, we are alerted, then we are able to quickly issue direction. So we are able to see whether, for instance, if that case has been filed with a prayer or a desire for interim orders, that is orders, for instance, to try and arrest a situation. So we are able to give a quick decision saying stop this before we hear the case. Then we give directions for hearing. Okay. Yes.
So at the tribunal, you're actually suing someone, isn't it? That's what actually is happening. It's just that it's not in court, but it's at the tribunal.
It is. It's a tribunal. It's actually. I know there's always been this discussion concerning tribunals, whether they are courts.
Yes.
I think that is now properly well established.
Yes.
If you look at Article 159 of the Constitution, it's very, very clearly that judicial authority is vested in courts and tribunals.
Okay.
And then when you go to Article 159 1D of a constitution, it says that subordinate courts include Cathy's courts, court-martials, and tribunals.
Okay.
So they are right smack right in the middle of the judiciary. And I think maybe it's good to also alert our people that actually in 2018, a case was filed, a public interest litigation was filed, which is petition 197, 2018, contesting the fact that tribunal members are ordinarily appointed by the executive.
Yes.
And somebody was saying tribunals are under the judiciary and there should be a separation of powers. And the court in, I think, 2021 affirmed that position. And then an appeal was filed from that decision. And in February of this year, the High Court affirmed that position, that tribunals are actually the exercise judicial authority, contrary to
So
some...
the appellant court also affirmed it.
Yes, the appellate court, the Court of Appeal, I think. Yeah, that was in February.
Okay, so then essentially I am suing somebody if I bring them before the
Yes,
tribunal.
yes.
All right. So what are some of the cases that we see in terms of character of these cases, and what would you see that would happen, that somebody would come before the tribunal? Slander, misuse of...
We have had... I can remember now one was even filed by a party who was not represented. And I think if I can remember the facts of the case was that in one of the newspapers, there was this notice, a public notice saying, take notice that Ndu does no longer work for the Standard Limited. Something like that.
Yes.
And was saying anybody who wants to know, they can contact us. So of course there was an implication that there was something fishy that had gone around it.
Yes.
And what was very interesting was that so they came to us. I don't want to go into the details of the case, but you could see the distress in the party, because ultimately what they were interested in was compensation. And we couldn't do that. But that would be one of the cases under the complaint. I know there was another case, a complaint as well, where a report concerning a certain public figure concerning some marital dispute and child custody, whatnot, and ultimately the tribunal found that that publication was a violation of a child's rights, because the identity of both parents was so well known that it was causing the children to be taunted and whatnot in court. So the court our tribunal actually fined that media enterprise for that. So that would be on the complaint side.
Okay.
As far as the appeals are concerned, most of the appeals that are brought before us largely are on the question of whether due process was followed.
Okay.
Because if you are going to come up with a decision that is adverse to a licensee of the regulator, then the regulator must follow the dictates of the Fair Administrative Action Act, which talks about giving person notice before you take that adverse action. And what has been very interesting is that on most occasions we have found that even if that decision might have been correct, the fact that due process was not followed invalidates the decision, irrespective of its merits or not.
So we're not looking at the outcomes, but you're looking at the channels through which these things was done. And I think it's important for us to look at the issues, because it's essentially what makes up the reasons why somebody would come to a tribunal or not, for them to understand what happens. So if we're talking about due process issues as one of the major things that comes before the tribunal, most times, if you look at a case where somebody was dismissed for whatever reason, but they were not given notice, like you say, due process, how then do you rule for this person to go back to the place where there's this animosity already? Because these are the things that somebody would think, okay, fine, if due process was not followed, how about you compensate me, instead of now saying that I be reinstituted back to the organization. And that would then hinge on whether I bring my case before the tribunal or not. So or does it really depend case to case? There's no one blanket way in which you adjudicate over these things.
Yeah, because the fact of the matter is that a tribunal is moved. So you only deal with the facts that are placed before you and the questions that a party agitate before you. But maybe back to the point of procedure, is like justice is also about process. You may get a positive decision, but in a process that could be said to be almost illegitimate. Maybe in a sense that maybe the judge was unfair to you, and that happens a lot. Maybe you are not given enough time to answer the pleadings. The decision may be correct ultimately,
yes,
but there's still an infringement of your right to access justice in a comfortable manner. Because justice is also about the process. The process is because it says that justice must not only be done, but it must be seen to be done. So that at the end of the day, even if the authority could have arrived at the same decision, but they didn't give you an opportunity to answer the charges or the complaints that they have against you, then it is still an irregular decision.
So two people are in this room, and I mean, we can be honest, right? We can have these conversations and be very clear about what we are saying. That two people are sitting in this room. We've given them a platform in the Situation Room to talk about issues. And because this is one of the examples that you gave. So we have no control over the words that are going to come out of the mouths of these two people. We've given them a platform to. We are not prophetic. We don't know what they're going to say. As a result of them being here for 1 hour and having this conversation, things have been said. Emotions have risen, whatever has happened. And then somebody says the platform upon which this conversation was had is the one then should be liable for any kind of damage that was done. Where do we come in here if somebody now brings us before the tribunal and says, now you have a case to answer? I could not control what these two people said.
Well, the way I could look at it, yours is a little more grey because some of the ones we have had are outrightly, you could almost see it. For instance, I think we've had situations where a media enterprise, I think one of the cases, invites what they were calling a sexologist to come and talk stuff. And that information is transmitted during
what is not watershed.
Yes, outside the watershed hours of 5 a.m. and I think 10 p.m. Then that one, it is so obvious, and you are saying you invited this person. You could have foreseen the content. You knew the topic. I think this other one, you still be held liable in the sense that, for instance, if in a newspaper you report what is clearly a defamatory material, of course there is also opportunity giving people a right of reply. So there's all that. And I think the programming code then would give the details as to what should happen. If, for instance, if somebody is saying something that's defamatory, then probably you should also invite the other person to answer, to give a reply, and a correction is made in the same prominence that publication was made. But I think maybe each case should be looked at on its own merits, because it is possible also the media enterprise could be the one that is egging the interviewee into a particular direction, and they can see what the outcome of this discussion would be. So then that could be said to be liable to the extent that it is quite clear. When you look at the transcript, you can see they were setting up the person to say
a certain thing or to go in a certain direction.
If I may ask, who exactly is permitted to come to the tribunal? Who comes to the tribunal? What do I need? What do I need to be aggrieved about? What conflict must I have and experience in order for me to come to your tribunal?
If your you're coming to appeal from a decision of the of the authority, on most occasions will be a licensee. So you might be a provider of courier services, postal services. You might be a media enterprise or a telecommunication services provider. Those will be typically the people who bring those cases.
So if my neighbor keeps parking in my parking slot, I can't come to you.
No,
you can't come to the Communications and Multimedia Appeals Tribunal. We are having a conversation this morning with the Honorable. My goodness, CT. The Honorable Rosemary Kuria is the chairperson of the Communications and Multimedia Appeals Tribunal. This is our Justice Thursday conversation for today. In court, because we said that access to justice then can be established or realized through courts and tribunals. And in court, you can have private citizens coming forward with petitions. You can have anybody really bring a case before court. Government can come before court with a case. At a tribunal where coming to the tribunal where somebody feels seriously aggrieved over something, it could even be government. Can government bring a private entity to a tribunal?
I've not seen a situation where government has required to come to us. Because the nature of the people who will have been aggrieved are either private enterprise or individuals. So government has not required to come to us. I think because of the scope of what we deal with. So government is never a party. Yes.
Okay. We've also seen that coming to a tribunal, you don't necessarily require representation of the legal nature. So you can come before the tribunal. In the age of social media, like you mentioned, there's a lot of new media that's popping up, and not just the people who are doing programs, but the nature of the platforms, whereby you had radio for the longest time, you had TV, which in some parts of the world is still considered new media, and then now you have this new thing, which is social media, which is not even 20 years old. So it is moving with the times, and people aren't able to say anything when they want it, how they want it. Has this opened the door for more cases to be brought to the tribunal because of the transforming nature of media and communications as we see it?
We haven't seen that, and I think that is, in fact, I think last year or the year before, we were having that discussion. I think the Communications Authority interviewed me on that issue, and I raised that issue, that we may talk about the traditional media, but yet there is the question, who regulates the upcoming media? But because the Act talks about licensees, but since media has been liberalized, then the question, then there needs to be some kind of regulation of that media, because that media is, even with all due respect to your good selves, is becoming almost even more powerful. It's even than traditional media, legacy media. It's source of information, source of opinion, can ruin reputations, is source of news, and yet is unverified news, and it's news that is not subject to any particular law. So I think it is important that the regulator extends its tentacles to cover that. I don't know how they would do it, but there needs to be something to be done.
You know, early on in the morning, we touched on this, and I gave an example. It's interesting. The first time President Trump was elected, media the world over is facing some monumental changes.
Yeah.
The readership of the hard copies keep reducing. But during the first time President Trump was elected, social media simply burst its banks, and all manner of news flooded social media. So half the time you are never really sure what it is you are reading, hearing, seeing. People then sought and started looking for credible data. Now the New York Times, which had been on a serious decline, suddenly picked up. They got very credible writers, people who were known. They reduced the size of the paper, but the publication and what you may call the readership increased. Now, their online publication ballooned, got to up to 10 million subscribers. Meaning, sometimes this thing which the liberalization allows is good, because then the citizenry have an opportunity to pit what they call credible news processes with one which is just up in the air and hardly ever. It takes time for people to actually understand it, but we are still in that nascent stage where we actually like sensational news. We don't really care very much about its authenticity, and that's where the regulation comes in.
I think even as we talk about regulation, City, if you look at the upcoming media, still the regulator or the people who gives licenses to the Xs to operate still has to go through the Communications Authority of Kenya.
Yes.
Whereas now you find that at any given point, if the media, the government would decide to muzzle any upcoming media, then the recourse would have to be that maybe an individual would come to the tribunal seeking that issue to be addressed, because then again it is the regulator who is, say, blocking X or Facebook. Would that be the case, that I bring it to you so that it's opened up?
I'm not quite getting the question.
The government, the regulator, the Communications Authority of Kenya decides that today, because X is doing A, B, C, D, we decide to shut it down. But as a consumer of X who does business on X, I feel as though I am aggravated and I needed that issue to be addressed. Would that be basis or grounds enough for me to come to the tribunal to seek that the regulator, who's CAK, to open up X so that I continue doing my business?
You could talk about, because that's still a licensing issue. Yes. Though, of course, the bigger issue is that those people are not licensed. And I don't know how they'll be brought in. Because we talk about fake news, we talk about accountability, and as you are pointing out, CT, quite correctly, we can say that this media enterprise, where we are today, the Standard, it is understood to be a credible source of news. Of course, many times we want gossip, it's more interesting, whatever.
It's more pleasant to consume. Yes.
But at least you're under. So if you say something that somebody considers to be defamatory, then you're required to retract. You are required to publish it with the same prominence with which you published it. But the question then becomes, this upcoming media, when do they retract? They are messing up people's reputations.
They do
with impunity, and nobody. And once your reputation goes, it has gone. You have no forum to tell people, no.
Give me back my reputation.
Yes, that was just gossip from the streets.
So the shift from traditional media to what we see today, with the proliferation of anybody can, get a microphone and sit in a room with a screen and do anything. They can say anything. So with the non-regulation, how then is it possible for us to adjudicate over things that are not regulated? Number one, somebody may say something defamatory about me or CT or you and puts it on their channel, wherever, says it. This thing is not regulated. Can I now bring a non-regulated entity before the tribunal and say, adjudicate over this matter where they defamed me?
I think it would be possible to expand the definition of a media enterprise. Because I think because what is media? It is passing on information. When it comes to of course, appeals, we are talking about appeals from decisions that relate to a licensee. But I think if you are talking about libel or slander, then I think one could expand the definition of a media enterprise and say, even though you're not licensed or registered anywhere, you're passing on information for the consumption of the public, and therefore you are responsible for its effect and how it affects other people. I think we should be able. I think of course we don't want to, I don't know whether anything will come to us, but I think it would be possible to expand the definition of media so that we say everybody who sits in front of a mic and talks stuff, shares opinions that affect other people, that is media.
I think it's already been defined. That's why it's called social media.
It is.
It has already been defined. Now, the work that your tribunal does, how does it benefit all the counties in this country?
All the counties. We sit virtually. So it means even though our headquarters, let me put it, is in Nairobi, anybody, you file suit from wherever you are. So even though you may write at the heading communications and multimedia, you don't even say Nairobi, because you can file suit from any part of this country. So it affects everybody in this country who is adversely affected by a decision of the regulator from every corner of the country is in a position to approach us, file suit virtually, and we hear it from wherever the person will be. Okay. Because we do virtual hearings.
Do you handle financial matters? Let us say an entity that is licensed by the Communication Authority is in the doldrums and has problems with paying what it is that they owe. Can you be an arbitrator in such matters?
The only issues that have come is when somebody has not paid their dues, and then maybe the regulator wants to cancel the license because you're not complying with the licensing conditions. So those issues we have dealt with, and I am aware of a suit where they entered into a consent, the regulator, and so that they are able to pay their dues in installments, which is to me that's a win. Because then you don't shut
It's
off.
a win for both, isn't it?
Yes.
You don't have the whole amount at once.
Yes.
This other side is saying, well, at least get me something as opposed to losing.
Yes.
So the tribunal then would be able to come in whereby you say, okay, and so you're not dealing with a situation where you're trying to put everybody out. And we're looking at fairness and justice here, whereby both sides then can come to a place whereby, at the very least, is comfortable for everybody. Is that the aim? Or is the aim for justice to be served?
I think the general conversation now about justice is a win-win situation.
Win-win.
And that's why we're encouraging alternative dispute resolutions. Because the beauty of encouraging negotiations and settlement is that decision is respected. Because when you have an enforced decision, which is what most decisions are, sometimes you encounter resistance. But when it is a negotiated decision, it means nobody's ego has been,
bruised.
Yes, bruised. So then you are able to then that decision is likely to be more easily enforced because everybody feels that they got something out of it. So as a tribunal, if a party comes and says, I think we want to talk, we say go right ahead. Okay. Of course, we want to give them a specific timelines because we don't want the discussion to go on endlessly. But we encourage that because we know that decision will be more, let me use the word legitimate, stretching the word legitimate in terms of is acceptance. The person, each party will be thinking we got something out of it, we were not unduly humiliated, and therefore we'll agree to its terms because we contributed towards those terms.
Today, if I want to file a matter with the tribunal, one of the issues that I've been accustomed with the judicial system is the time taken in prosecuting matters. So if I bring a matter before the tribunal, are there timelines upon which a matter is being heard before I get a feedback or a ruling?
Actually, and I think this is one of now the beauty of the current judicial system we have in this country. In every judicial officer, including ourselves, the tribunal, we are subject to a performance measurement. Because before, there used to be the question, how do you regulate, how do you supervise decisions, and there's the independence of the judiciary. But right now, there's very clear accountability. When we sign PMMU, because the performance measurement, whatever, with the Chief Registrar of the Judiciary, there's a requirement that a matter that is filed before us must be concluded within 180 days. But that is on the outside. Okay. So, the people who are looking at the files are curious. For instance, did you give it too many mentions? Because it's like every step is now, I think there's much more scrutiny of how you did it and how fast you did it. So that, for instance, once you conclude a matter, you are required to ensure that, for instance, you deliver judgment within 30 or 45 days. So it is... And right now, like in our tribunal, we are not even so busy, so we would even be able to substantially cut that period.
How many are you in your tribunal?
In our tribunal, we are 7.
Mm-hmm. 7.
We are 7, so that there's the chairperson and 6 members. But the quorum of the tribunal is a chairperson and 4 members.
Okay.
Yeah.
So, I mean, obviously looked at time, looking some of the subject matter or some of the areas that you actually then deal with. When we look at, some cases that are adjudicated over, the atmosphere or the current, situation is taken into consideration from what we understand from judicial officers when judgments or rulings are being made. This might be a little bit different from what I'm understanding. Do you look at clearly what was said, what was done, and how it was and how it happened, or do you look at the effect that it would have had when you're making the ruling, and then what kind of compensation do you look for? Monetary compensation, apology in the public, recalling of certain statements having been done? It seems like a number of things then could be called upon. Which ones do you lean towards?
When it comes to the complaints, our section 102E gives very clear boundaries as to the kind of remedies we can have, we can give. So they include retraction, an apology. There's also the fine, depending, of course, of the nature of the aggravation or the mistake that was made. When it comes to appeals, we will want to be guided by the law and the facts, because the problem I see is that you don't want to go. You see, sometimes when they talk about judicial activism, I take it is where a judicial officer or a court decides, act as if they have an interest in the case, or they have special information concerning the circumstances of the case. And yet it is the parties who come before you who should tell you what they desire. So on the whole, we have not put ourselves in a situation where we are trying to think about the greater good or other issues apart from all the facts that are brought before you. But if a party probably points out into all this, please consider what this would do to the body politic, then we could consider that. But so far, and I think it is much safer to restrict yourself to the facts and the law.
Okay.
Because if you go outside, then, in fact, they used to say public policy is an unruly horse. It takes the rider, he knows not where. Because once, if you open the door to say, we want to consider how this might affect this, that, or the other, where do you end?
Where do you end?
Yes.
So even the question about where do you end still comes back to freedoms. We mentioned this a little bit before, but we often bring in, comments and, thoughts that we have from our folks who are tagged in. And this is something that I think you might be interested to hear, Honorable Kuria. Anyone who sits in front of a mic has the right to exercise their freedom of speech and expression. Social media doesn't require a professional license. So you see where we are? When you're opening the door, when you're talking about my freedoms end where your nose begins, a tribunal or even the courts, how then do you deal with? That's the sentiment out there, number one. So if I have freedom behind a mic in my little room with my green screen, I can say whatever I want. If it hinges on your freedoms, then I'll say, well, I have the freedom, so I can do. How then do you deal with and that sentiment that's in the public?
I think that's a clear misunderstanding of even how rights operate. Because even you look at our own constitution, and I dare say, even the very people who would be saying that, if their own rights, the right to repute a good name, are violated, the same ones doing somersaults, crying what has been done to them. So I think it is possible for people to say it when it doesn't affect them, when it doesn't affect their loved ones. But I think people ought to understand how important somebody's reputation is, and that even the Constitution itself, even the Bill of Rights, always places a limit to the rights, because no right is absolute. If you think any right you can think about, right to movement, it is curtailed by the law of trespass.
Yeah.
The right to free speech curtailed by the right of the rule against slander. So the right to property, there's a law of theft. So there's always a balance concerning the right. So no right is absolute. And I think it would be good, even those ones who are saying they can say whatever they want, I don't know whether they quite believe that, if they thought that it was applying to them.
Freedoms by their very nature are actually alien and contrarian to our own human nature.
Yeah.
In this sense, they're alien because when you grow up in an African setting, freedoms are limited severely, because you live under the rule of your father and mother, and those rules are usually quite strict. But we live in an era where they are less strict, okay? But even then, there are still rules by which you abide.
Yeah.
So when you become an adult and somebody then tells you go to an institution of higher learning and suddenly that immediate supervision isn't there, you will test your wings and you will test your ideas. And that is the reason why student populations are the ones who are perhaps the easiest targets for new ideas. They're the easiest targets for people who express themselves without understanding the consequences. As you mature, experiences normally have taught you that these limitations actually exist because your actions, your words have consequences.
Absolutely.
Now, in understanding the law and appreciating it, it is something that a lot of work needs to be done. I say this because if we do not take the time to teach this from the very time that children are young to understand the law, because the process of understanding the law is where we can inculcate patriotism into our children.
Yeah.
So they grow up understanding it. But there are many people who don't understand that very freedom they have is what they use against the very nation that they belong to.
Yeah.
Yes.
Yeah.
So it becomes, as you said, destructive. Now let me ask the question. That was just me ranting.
Okay.
In a minute, how are members of the tribunal appointed?
The chairperson is appointed by the Judicial Service Commission competitively, and the chairperson can only do 2 terms as a chairperson. So you're eligible to 2 terms of 3 years each. Then you're done. The members of the tribunal who are drawn from different, they are a mix. So you have legal and non-legal. So you'll have may have a lawyer or 2. Then you can have members who are experts in telecommunications, IT experts, people from media and other places. Okay. Those ones are recruited also competitively by the Ministry of ICT. And that's where I was throwing in the issue that was arising concerning whether the executive should recruit members of the judiciary. But for now, we have them, and I think we are all doing a fairly good job.
Enhancing access to justice through tribunals is another way in which it's done. We want to thank you for sharing this information with us this morning. Always good to know the options that Kenyans have bringing justice essentially to their fingertips. The Honorable Kuria has been our guest this hour, and we've been talking about, access to justice through the Communications and Appeals Tribunal. Honorable Rosemary Kuria, thank you so much for joining us this morning.
Thank you for having me.
This is the Situation Room, the only way to start your day.